right, back on record on Edgecomb. Who are the defense additional witnesses? Just in order, please.
Judge, so we have Mr. Edgecomb, we have Dr. Black, we have maybe a substitute witness from the medical examiner, which is very short, I imagine 5 or 10 minutes, and potentially Dr. Kelly also 5 or 10 minutes. Maybe one more officer, Detective Kirk Vole, to step in for Detective Klabundy.
Hang on, Counsel, can you use the mic? I can't hear you.
Sorry, Judge. So I think we have a total of 5.
Your client, Dr. Black, an officer, and who else?
Medical examiner or the toxicologist. We've subpoenaed them both. We did have contact with both of them. They are available tomorrow morning, and that would be very short. I do think we will wrap up. We'll be done before the lunch hour with our case. But we did, Judge, want to address some issues regarding Mr. Edgecomb's testimony, the number of priors, and a couple of other issues which we put on the record. I think if we could address that now, we can start right away, and I think it would make sense, given that it's 4:30, to let the jury go and for us to just deal with all this until 5.
Is the state, based on what you know right now, anticipating any rebuttal?
Possibly. I don't know, but I did put on notice the possible rebuttal witnesses, and then there's actually more based on what the defense has provided. I don't know how many I've used. I don't think it'd be more than 2 or 3. And I haven't, I'd have to wait to see. As it stands right now, no. But depending on what they bring in tomorrow, possibly.
Fine. All right, I'll bring the jury in. I'll discharge the jury. It's 4:30. We can discuss some of these issues, and I'm going to expect the defense to have all their witnesses lined up and ready to go at 8:30 tomorrow. If the state ends up with rebuttal, I'm going to expect the state to have the rebuttal witnesses ready to go promptly tomorrow. I'm going to tell the jury that we are going to finish certainly with testimony tomorrow, and hopefully the entirety of the case. Deputy, you can bring him in a minute. So I'll discharge the jury with the thanks to the court and the parties, and then we can discuss a couple of the witness issues. All right, welcome back, ladies and gentlemen. It's 4:30. Where we stand is this. The state, as you know, concluded their case subject to rebuttal this morning. The defense has been calling witnesses. The defense has a handful of other witnesses to call, approximately 4 additional witnesses. I am 100% confident that we will conclude testimony tomorrow, and hopefully conclude the entire case and submit it to 12 of you for deliberations. But we will certainly conclude testimony and hopefully conclude testimony in the morning. The witnesses that are anticipated tomorrow, a couple of them are going to be very quick 5 or 10 minute witnesses. There'll be a couple of others that may be a bit longer. I need to discuss a couple things with the lawyers. You don't need to be involved at all, obviously, with what I'm going to discuss, but I need to discuss some things with the attorneys. So I'm going to excuse you for today a bit early. I'll stay for the next 15 to 20 minutes to discuss the things I need to discuss so that tomorrow the witnesses can move promptly along. Obviously, you've heard these directives and my warnings multiple times, but I'll say them again briefly. Please don't discuss this case. Don't do any deliberation. Again, that means if 2 of you are on the elevator or 3 of you are at lunch tomorrow, don't discuss anything about the case amongst all of you or any of you, group of 2, group of 3. Again, don't do any research in this case. And very importantly, there has been and is ongoing media coverage of this matter. That includes some video coverage. It includes written coverage. Please avoid that. Please do not watch the local news tonight. If you see something in a newspaper, if you see an article, please don't read it. As I've said earlier, you need to ultimately make your decision and reach a verdict in this case based only on the evidence that's been presented during the trial. That means the witnesses, the exhibits, the videos, the things you've seen over the last number of days, and we'll probably finish up with seeing tomorrow. I appreciate all of your efforts To my observation, you've been very patient, you've been attentive. I used to say 200, but by now it's probably 250 or 300 jury trials in my career. And I can tell when a jury's paying attention, and I can certainly tell that you've all been paying attention. So I appreciate that, and the parties appreciate that. Please be back tomorrow again, 8:15 or 8:20, and I'll try to start again as close to 8:30 as possible. I think that's it. If you have any questions, let my bailiff know on the way out. Follow my bailiff out. We'll see you tomorrow morning. Thank you, everybody. Everybody else can remain seated, please, while the jury is out. All right, the jury's been excused. We can discuss the issues. First of all, the parameters of Dr. Black's testimony. We discussed that a bit before lunch. My understanding is that the defense submitted within the last 2 days, Saturday, some video footage or something that was either compiled by Dr. Black or modified or something. The state objected. My concern is it's clearly unfair surprise. As I said before lunch, and I'll hear from both sides briefly, but in looking at this case, the defendant was, and again, the jury's out, the defendant was charged in March. This case has been pending for 10 months. There are at least a dozen motions in limine filed by the defense. We've had 2 separate motion hearings, and here we are 4 or 5 days into a trial, and I find it clearly to be unfair surprise and undue surprise to have a witness testify to something, I'm not clear what, in a video when that was not noticed in the notice of expert testimony. At lunch, I reread the document. Barb, can you print that for me? The document related to Mr. Black's testimony, and I will read parts of it into the record, but in no point in time does the defense ever indicate that there'd be video that he would be modifying, testifying to, using, and in fact, there were conversations during the motion hearings regarding what he would testify to, basically that being exposition testimony. And candidly, while my clerk's printing the notice that was sent by the defense, the notice of expert testimony, arguably some of the things that Mr. Black is going to testify to are pretty much in the common knowledge and purview of your average juror. I'm willing to, as I said earlier, allow him to testify with appropriate parameters. I'll hear from the state first. I want to review the document again, and then I'll hear from the defense briefly. And actually, let me hear from the defense. I'm not clear what would be offered, and B, I'm not clear why it was given to the state 2 days ago on a weekend, 5 days into a homicide trial, with a defendant that was charged 10 months ago. I mean, that's not the 11th hour. That's middle of the game, fourth quarter. Mr. Ahmad?
Judge, I understand the state's objection on that, and again, this is not something we had, but just to clarify what it is, it's just an excerpt of the original video is one file, and it's short and it's played in slow motion, and then the other one is an enhanced version of that just smooths out the corners. We had a different video expert, Mark Robinson, for a video, but this was just something that when I met with Dr. Black in person for the first time, up till now it's all been by Zoom, this was just something that he had done for his own sort of understanding. Now, we never noticed about him testifying as to any events in this case or any facts in this case. It was purely expositional. This is just something that he also has some familiarity and expertise in videos, and so that's just something that he had done internally for his own sake in this case. So as soon as I got the links, I sent that to Attorney Huebner, and I believe he's objecting to that, but just want to clarify, it's a snippet of the original video. It's slow motion and it's short in length. It's just mostly from I believe, both videos in length are from less than 30 seconds, and they capture the event from from the second video, the pole cam facing Holton, where there's some running that is observed, and the ultimate encounter in the case of the shooting.
Mr. Huebner.
Microphone, please.
Yeah. Your Honor, the notice about Dr. Black has been assured to the state many, many times by the defense that he would be testifying only to expositional testimony. When I asked what they meant, they stated he would simply be testifying as to, I guess, hindsight bias and the fact that video captures more.
Let me interrupt. I apologize. But I'm not sure if there was an original notice of expert testimony, but the amended notice, which was filed just over a month ago in December, says, and I'm just going to read parts, Dr. Black will testify and explain concepts of hindsight bias and outcome bias. Dr. Black will also testify about factors that affect a person's attention. Later it says he will discuss video evidence and how a two-dimensional representation of a three-dimensional event can be a factor. Going back to there was an original document, original notice of expert testimony, which was filed about 10 days earlier on December 7th. Again, it says paragraph 1, he's going to testify to allegedly an analysis of, I don't even know what this means exactly, but use of force guards against injecting hindsight. 2, a proper review or analysis remaining grounded in evidence. Then it talks again in paragraph 3 about hindsight bias and outcome bias. Then in paragraph 4, it's recognized allegedly when using physical force, decisions occur in a dynamic, rapidly changing situation. Then there's other things about generally videos. Again, some of this I think arguably is in the common knowledge of a juror. For instance, paragraph 6, video recordings do not necessarily represent the observations of the people portrayed in the video. Well, obviously, you have a video on a pole cam that's half a block away that doesn't portray either Mr. Edgecomb or Mr. Cleereman in their ultimately fatal confrontation. It's not a video of either of them standing right behind them when this occurred. So the state can continue, but
We had noticed and we had a discussion about it was because my concern has been and will always be that I was worried that there would be an attempt to have experts testify as to whether or not something was or was not reasonable, whether or not something was or was not an actual threat or a belief in a threat. Defense counsel assured us, me on the record, and when I objected to it, saying no, this is going to be simply expositional. There wouldn't be any testimony of Dr. Black specifically comparing anything that the defendant or the victim did in this case. That we had no discussion of a breakdown of video or that to be any testimony as to the video. So if you look at what they noticed us on and what I did not object to, there's no reason to play this video because they're talking about it basically in the abstract. The only reason to play this video is an attempt to sit there and point out things in an attempt to subscribe knowledge or intent or reasonableness to one of the parties involved.
right, let me jump in. I'm sustaining the objection. Dr. Black can testify. It's been indicated multiple times by the defense what the parameters of that testimony is going to be. It was indicated on the record more than once that it's exposition testimony, period. That's number one. Number two, it's unfair surprise to hand the state something on a weekend, 4 or 5 days into a homicide trial, and then now indicate that an expert is going to testify about a video that he may have modified or manipulated. There's no need for it. The defense has indicated it's exposition testimony. I will allow the exposition testimony that does not connect itself directly to this case. Playing the video obviously would violate what was indicated previously in the notice of expert testimony. It would violate what the defense has indicated to the court. It would be this witness potentially opining on the behavior of the defendant, which is clearly inappropriate. On top of everything else, the video that's being referenced, or the parts of the video, have been played time and time and time again. For all the reasons I've already indicated, and it's cumulative, that testimony related to anything being shown to Mr. Black from any video is not allowed. I'm sustaining the objection. In terms of the defendant,
More clarification we need on Dr. Black. So I understand it's exposition testimony and there are parameters established based on our notice. The question is, what are the limitations on cross? Because the defense is not prepared to talk about any of the facts in the case, any sort of video, anything relating to use of force, because that's not going to be a subject of his exposition testimony. Then the state shouldn't be allowed to have a wide open cross to start getting into these issues either. But I believe the state believes that it should be able to have a wide open cross and open the door if it wants, and then we can rehabilitate. But we're not prepared to get into that because that's never anything that we've noticed on.
Mr. Hubner.
Your Honor, I plan to cross-examine the witness based on his testimony. I don't know what defense counsel's talking about.
Right, I agree. The state will cross based on the testimony. If the state goes in cross-examination, no pun intended, across the line, I'll tell them that and stop it. Let's now discuss the defendant. And I don't know what the state's going to ask on cross. I don't know what the defense is going to ask on direct. I know what my ruling is regarding the testimony. I expect both sides to comply with the court's ruling. There's the issue of the defendant. I'm presuming based on everything the state, strike that, the defense has said in their opening and to me multiple times that the defendant is going to testify. So there's a question of the defendant's prior record. It's my understanding from what was discussed earlier that he clearly, apparently, has a carrying concealed weapon conviction. Then there's the fact that the defendant pled guilty a couple of days ago, actually last week, to felony bail jumping and misdemeanor bail jumping. So I'll hear from both sides briefly as to what your position is on number of prior convictions if and presumably when the defendant testifies. Mr. Hubner.
Your Honor, he's got 3 convictions.
By that you mean the CCW, which was when?
Hold on, let me pull that up. I apologize.
So it's the state's position that the answer to that question should be 3. The CCW and the 2 convictions, meaning the bail jumping felony and bail jumping misdemeanor that the defendant pled to a week ago, correct?
Yes.
All right, Mr. Ahmad.
And I can tell, just so the court is aware, and I don't want to misstate anything here, that CCW conviction is in 2000, and it was a 2016 case. The defendant was convicted of that in October 10th of 2017, so 5 years ago.
Mr. Ahmad.
Judge, so as the court knows, there's a variety of factors the court can look at. So the language under the case law is whether to admit evidence of prior convictions. So how do we interpret prior? I've looked at the case law, Judge. I don't know if prior we're referring to prior to the time he testifies, but I think that generally that would be the rule. But in this case, we have something unique in that he's pled to offenses that he was charged that are of the same date and same transaction.
All right, I'm taking it under advisement. Both sides are to provide me with some legal research and case law or authority in this matter. I'm confident this is not the first time in the history of American jurisprudence that this has occurred. Find me a case from Wisconsin, find me a federal case, or find me persuasive authority, and I will weigh that along with the fairness and the equity related to the pleas. Obviously, the CCW counts as one conviction. Clearly, at a minimum, when the defendant testifies, he will have to answer at least one. The question will be whether it's one or three, or I guess arguably two. So I think really it boils down to one or three. So both sides, please do some research. Provide me with a case in Wisconsin. If there is one, I'm certainly not aware of a Wisconsin case, but the federal system has a very similar process and similar rule. Find me a federal case from the Eastern District, or find me some persuasive authority. It's almost 5 o'clock. We're going to break for there. I want all the defense witnesses ready to go at 8:30. That means Dr. Black, the police officer or officers, the ME, and obviously the defendant will be present. We're taking a break. I want everybody back at 8:15. We'll start as close to 8:30 as possible tomorrow. We're off the record. We're adjourned. Thank you.